All right, good afternoon, everyone. It is 2 o'clock, so we are going to go ahead and get started. Thank you for being here. We are so excited to be able to offer this opportunity. My name is Sterling Stopper. I am the president-elect for the Utah Association of School Psychologists. Definitely want to take just a second to thank our presenters for being here and being willing to share their time and expertise with us. Very excited to hear what they have to share with us and help us better support students in Utah. So a few things just want to go over real quick. A reminder, please stay muted so that we can hear the presenters. There will be different times where you can ask questions, and at that point you can go ahead and unmute yourself and then mute again. Just want to make sure that we can hear everyone well. There will also be several people monitoring chat, so if you have any questions, feel free to go ahead and add questions right in there in the chat, and we will we'll pause a little bit throughout this presentation and give an opportunity for asking those questions. Also, we'll have a Q&A time at the end when the presentation is all done. We will be taking about a 10-minute break around 3:30. And then just so everyone is aware, we are recording this session and it will be available to view later for UASP members on the members resources website. We can also email it out to any participants who are not UASP members, but that did register for this. So we all have access and we can see that. And then the last thing I want to share is that professional development certificates will be emailed out after. So for anyone that registered and that participated, you'll get that emailed out later with some instructions for Midas credit if that's something that you're interested in. So keep an eye out for that email. All right, so we're going to go ahead and get right into this. I do want to share a little bit about our presenters, and then we'll turn the time over to them. Ashley Biehl is an Assistant Attorney General for the state of Utah, representing the Utah State Board of Education. She received her law degree at the University of Utah S.J. Quinney College of Law in 2015. She subsequently practiced family law in Elko, Nevada for 3 years before moving to Legal Aid Center of Southern Nevada, where she represented abused and neglected children. She joined the Education Law section of the Utah Attorney General's Office in January 2022. And she is passionate about improving the lives of children through the law. We also have Holly Bell. They is the Student and Family Rights Specialist for the Utah State Board of Education. She's a passionate advocate for educational equality. She was a school counselor for 8 years and the Jordan School District Secondary School Counselor Specialist for 2 years prior to moving into her position at the Utah State Board of Education 5 years ago. She now assists schools and districts in Utah in meeting the federal and state regulations that protect the constitutional and civil rights of students and families. She also serves on the Utah Youth and Young Adult Suicide Prevention Work Group and LGBTQ+ Suicide Prevention Work Group. Her #1 priority is to ensure each student in Utah has access to high-quality education in a safe and inclusive environment. And we also have Tiana McCall, who is USBE's School Social Work / School-Based Mental Health Specialist. She's been with USBE for 2 years and previously worked as a school social worker with elementary students, where she specialized in serving refugee youth and families. She also has a passion for macro-level social work, which is what brought her to her current role with USBE. So with that, again, we want to thank our presenters, and I will go ahead and turn the time over to them.
All right, I think I'll be the one kicking us off. We're going to go high and then we'll go a little more narrower. So thank you, Sterling, for introducing all of us. I'm excited to be here to see you all. I recognize some names from my time in the school, so that's fun to see some familiar faces and names. So I'm going to go ahead and share my screen and just jump right in. All right, I'm operating on one screen, so bear with me as I try to navigate all of my things, but I just want to check. Can you see my notes or just the presentation? Just the presentation? Okay, I'm seeing head nods. Great. Okay. All right, so I am going to cover some school-based mental health laws and rules that are applicable to us as school-based mental health professionals in schools. We are going to cover kind of 4 main areas: parental consent, medical requirements, mental health screening, and mandatory reporting. So we'll start with the parental consent laws. So 53E 9203 is a state law that governs essentially parent consent for certain topics. So this law covers the administration of psychological or psychiatric examinations, tests, treatments, or surveys, analyses, or evaluations. It requires prior written consent 2 weeks before you get any of this information that's related to this law. It does include some exceptions. The exceptions are related to when there's an emergency situation or for child abuse and neglect reporting. And it defines when parents must be notified. So if a situation exists that presents a serious threat to a student's well-being, or if a student's at risk of attempting suicide, physical self-harm, or harming others, that is when we have to notify parents. This statute also requires that each school district or charter school has a policy and procedure about notifying parents in regards to suicidal ideation, self-harm, and harm to others. So you can check your individual school district or charter school's policies to see what you're supposed to do in the event of these circumstances, and you should follow those policies and procedures. Usually there's some sort of documentation process and notification procedure as well. Raise your virtual hand if you've ever heard the phrase, "We can see any kid once without parent consent." Okay, this is a fallacy. This does not exist anywhere in the law that I've been able to find, and maybe Ashley can help me find it in the law, but that is not true. Parental consent is required according to this law, and this is a law that should be referenced when you're seeking parental consent and your school district's policies and procedures about this. There's that commonly held misperception that we can do that. We can see any student once, but this law does not back up that commonly held misperception. All right, next we're going to take a look at medical recommendations. So 53G 9203 is a section in the law that talks about what we can and can't do in schools and say to parents regarding medical recommendations. In general, this law says that school personnel cannot recommend or require medication for attending school, psychiatric or psychological treatment for children, or conduct mental health related evaluations, except for school-based mental health professionals. So we are able to recommend but not require those psychiatric or psychological treatments or we can conduct mental health evaluations. And then we are also permitted to provide resources for referrals for services. So raise your virtual hand if you've ever heard anybody say, "We can't recommend treatment," or "We can't recommend students go to see a therapist." This law would suggest that there is some flexibility in here, that we can make recommendations. We cannot require it, but we as mental health professionals can make recommendations for students in this area. School personnel in this law is defined as a school employee, including a licensed part-time contract or non-licensed employee. And then later on in the law, it defines who is the healthcare professional and who is a school-based mental health professional. So that includes physicians, mental health therapists, nurses, school counselors, I don't know if it specifically calls out school psychologists, but it does say psychologists, I think. All right, the next one is mental health screening. So there is a law, and so a state law and then a board rule that supports school-based mental health screening in our state. About 3 years ago, 53F 522 was created in the law that sets standards for LEAs or district church charter schools to implement approved mental health screenings for students. And then it required that the State Board of Education create a board rule related to further defining what this looks like. So in our board rule, the R277625 defines an approved list of mental health conditions that can be screened for in schools, and that includes anxiety, depression, and suicidal ideation. So we are not allowed under the law to screen for any other mental health conditions such as OCD or I don't know, schizophrenia. These are the only 3 conditions that we can apply for or screen for. There's also an approved list of screening tools that the board approved back when this rule was created. So it's like a 2 or 3 page list of tools that you can use for screening for these conditions. And then there's grant funding available to support screening efforts in schools and to reimburse parents for getting their kids support as a result of their screenings. The most common question we get about screening is related to the difference between screening and assessment. So often the question is, well, this kid is displaying some concerning behaviors. We think he might have anxiety. We're going to use the GAD-7 with him. And is that considered a screening? At that point, no, that's an assessment. We're trying to figure out his level of anxiety. We already know he's experiencing some anxiety, so we're not screening at that point. Screening is really just identifying potential concerns before there's any knowledge of any concern. So if your district or charter school is interested in screening, we are in the process of receiving notifications from superintendents and charter school directors if they plan to screen for the upcoming school year. Part of the law in 53F 522 says that each LEA has to notify the state board of their plan to screen. And if they haven't notified us, they are not permitted to screen for mental health conditions. So if you're interested in doing mental health screenings in your school, I would reach out to your district or charter administrators to figure out if your school is planning to be doing screening. Then the last one that I wanted to cover is just all of these laws about mandatory reporting. So there are lots of things as school personnel and mental health personnel we have to report. So the first one is obviously child abuse and neglect, and there's laws. There's the law, the 53G1 and the R277 statute or the board rule that cover this requirement to report child abuse and neglect. So we're required at the state level law and the board level rules. Sometimes your district or charter school will have they should all have additional policies that define this. And some policies and procedures require that you notify an administrator as well. So you notify DCFS or law enforcement, and you tell an administrator in your school or in your district. 53G 8502 is a law related to another thing we have to report as personnel in school, and this is related to prohibited acts. And prohibited acts in this law is defined as related to alcohol use, controlled substances, and drug paraphernalia. So your district or charter should also have a policy in place for who to report that information to you if it's disclosed to you. And then the next one is suicidal ideation. I think we're all very familiar with this. There's a state law, so the 53E is the state law and the R277 is the board rule. Both of those support the same concept of whenever we know of a student who is at risk of suicide, we need to notify the parents to get them the support that they need immediately. And then 53G 9605 is related to bullying incidences, and we are required, school personnel are required to notify parents about any instances of bullying as well. And then the last one, the board rule 609, is related to emergency safety interventions, which I think we're very familiar with. Whenever we have to restrain a child or place them in a more exclusionary setting, we need to have a notification process in place so parents are informed. And that is my big overview of state laws related to school mental health. So I'll stop here and see if there's any questions about any of the content I covered. It's a lot, and it's a lot of numbers and technical stuff. So anyways, I'll let you guys ask any questions if any came up.
Josh, if you'd like to unmute, you had a question in the chat.
Yes, I was just wondering if Panorama, which is not, it's kind of a district-wide but pilot project, is that listed as a screening tool for mental health? I mean, they're using it in that way.
Not a tool. It would be like a platform which you could ask questions related to mental health or social emotional concerns in there. So it's not a tool in itself. I know many districts who are screening use Panorama to do that work, but it would just depend on what questions you were asking if it would fall under the category of a mental health screening.
Yeah,
so if any,
that's how it seems like it's being used right now. So that's why I'm wondering if they're asking those questions, how does that work as far as like approval and et cetera?
So if they're asking questions that are directly related to suicidal ideation, anxiety, or depression, they would need to get those questions approved by the board for them to be considered an approved tool, essentially. Many people who are using Panorama are asking questions like, how are you coping? Or what are your, how are you feeling? Some of those that are like kind of skirting around the topics, but not asking directly about the conditions. All right, well, I'll pass it on. I'm not sure if Holly or Ashley is going to go next. Yeah, I'll grab the link and I'll put it in the chat for the approved list of tools, Sammy. But I'll turn it over to them. You'll probably see some of these laws pop up in their presentations as well, because they are all kind of related to all the things that we're talking about today. So thank you guys.
All right, I'm going to take it from here. So thanks for the invite. As was mentioned before, I'm Holly Bell. My pronouns are she, they, and I'm going to present to you today on LGBTQIA education policy and practices. So while I was listening to Tiana, I was thinking, I made this handy little chart on all of these different, like the whole process of law, because I remember when I came to the board, well, when I went to the district office, I was first introduced to kind of statute and rule and what those all are and how it all works. But I remember prior to that, I was like, I don't even know what all of those are. So I can't find this little flow chart that I made, but I'm going to give you just kind of a basic overview of that real quick. Just verbally, but I'll have my slides up. So how it works is you've got the Constitution, everything starts there, goes down to the federal level. And Ashley, you can also chime in if I get anything wrong. So you go down to the federal level, you've got different levels, but you've got federal law that is interpreting the Constitution, as is the court system. From there, from federal law, you've got some they pass off some interpretation that needs to happen to different agencies. Like in my world, the Office for Civil Rights is one of those agencies that takes those federal laws, and they will make regulations. Like you may have heard of Title IX, which is what we are, the LGBTQIA population. They're protected under Title IX based on executive order, which is the office of the president. But they're not officially in the Title IX regulations. They are proposed to be, but OCR takes federal law, they make these regulations. And from there, they also make guidance, which they have based on this executive order that came out. And you can look at it on the Office for Civil Rights website. It's called Protecting LGBTQI plus Students in Schools, I believe is what it's called. It's got a lot of resources, so check it out. So that's kind of how it goes on the federal level. Then it comes down, and Utah has a constitution. And then we've got laws. You'll hear it called statute, code, or just law. We take all of that, comes down from federal level, state or U.S. Constitution. We've got our own little constitution. We make laws called statutes, and every kind of little area has a different number attached to it. So where you saw the 53E or 53F or 53G dash blah, 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 that's statute, code, Utah law. And then they say, hey, we've got this Utah State Board of Education. They know more about education, or at least sometimes we pretend like we think they know more about education. And so we want you to take this law we made and we want you to interpret it and make a rule, an administrative rule out of it. And so then you'll see all of these R277 blah, blah, blahs. That is administrative rule, or rule that is out of the State Board of Education interpretation of law, but sometimes they make their own. They're like, I mean, it has to be in line with state law and federal law, but they're like, well, we think this needs to happen in schools. And so the stuff that comes out of the Utah State Board of Education is law. But then they also say they'll put out guidance documents and best practices and things like that, which is not necessarily binding. So when you see all these numbers, hopefully that makes sense, a little bit more sense of what they are, how they work. And that's a crash course in law and policy. You're welcome. There will be a test at the end. So when it comes to policy around LGBTQIA plus students, this is a tough one, because the number one question I always get is, Holly, what can we and can we not do? And I'm like, I would love to know how to answer that question. There are not a lot of black and white answers right now. There haven't been for a while. And then when there are, they change. We're all over the map. So what I'm going to try to do is give you an overview of the landscape and give you some kind of questions to ask yourself, a broad framework so that you can be able to make informed decisions. But I'm not going to be able to give you a lot of black and white answers. The Utah State Board of Education, we were working on a guidance document for a couple of years, and they decided, never mind, we're not going to do that. We're going to leave it up to school districts to make those decisions. Now, that may be frustrating, but then if you think about it, I don't know, sometimes prescribed rules aren't ideal for all kids. So I don't know. But that's what we're left with, is districts and schools making their own decisions. But they need to be informed decisions that are best for students and families in Utah. So that's where we're going to try to go. So Sammy Tibbetts, how did your presentation go today?
It went so well. Thank you for asking. Everybody was really receptive and it was awesome. So
excellent. Sammy had interesting timing where she had to give a presentation kind of on this before mine. So we talked ahead of time. All right, so let's put ourselves in the right mindset. In 2021, the Utah State Board of Education wrote a resolution. Resolutions are not binding by law, by the way, and you might hear those and in the legislative session, the Utah resolution, blah, blah, blah. Blah, blah, blah is official legal jargon, in case you were wondering. I think it's Elaine Bennis from Seinfeld. That was her phrase. So as we're thinking about our kids, all of our kids, Utah schools should be a place where all students feel safe. And my little thing is blocking my screen. Okay. Feel safe and are given equitable opportunities to succeed. Utah law provides that every student in the public schools should have the opportunity to learn in an environment which is safe, conducive to the learning process, and free from unnecessary disruption. There's a statute right there, code 53G8202. And all students have the ability to learn, and that each student departing the system will be prepared to achieve success. All right, so I'm going to go through this little FAQ. These are the most commonly asked questions, and I'm going to do my best to answer. And especially for a school mental health provider. And I come from a background in school counseling. So these were questions that came up for me all the time. So I'm sitting in a room, my office with a student, and they say, "Hey, Ms. Bell, I'm gay," or "Ms. Bell, I'm transgender, I'm non-binary." So what happens now? Tiana basically did a quick overview of, or more thorough overview than I'm going to give as far as what confidentiality goes. And so the law applies here, as well as far as like parent permission, no freebies, you know, sexual orientation, gender identity, sexual behaviors, orientations, and attitudes, under which law is that offhand? 203? 53 G9203, is that the one, Tiana? No, mandatory, okay, anyway. So that informed consent has to happen if you're going to get into the details of sexual orientation and gender identity, which is that our place? No. Is our place to support students in their growth and development, their academic progress? Are these things, there are different parts that are their identity influencing them as we go, you know, through their lives, and that are very difficult, even more difficult for some, especially our LGBTQI students. They have a lot of additional challenges, you know, based on, I mean, it's based on the individual, but they also have some additional challenges when they're going through this development process. So, but getting into the details of all of that, we don't do that with any student. As far as really diving deep into their sexuality. But is it a part of who they are? Is it part of their identity? Yes, and it's an important part for them. Our sexual orientation or gender identity are typically a part of our identity that are important to us as individuals. They're not the only parts of us. We all have, we're multifaceted individuals, but these two parts of their identity are important to them, and they'll talk about them. But if they come out to you, just like a straight student might come out to you, usually they don't say, "Hey, Ms. Bell, I'm straight," but they they might tell me that they like someone of the opposite sex. I go, "I love that for you. Okay, so how's everything else in your life?" But then if they say, "Ms. Bell, I am really struggling with this," I say, okay, now that might be getting into more of a conversation where that FERPA form, well, not officially FERPA, but that parent consent form, we need to start maybe thinking about that. And, you know, how can I help you in your social development and in how this is impacting you and your progress here at school. So, but you do have confidentiality applies in your position, in as much as it follows those rules where if there is not a serious threat, if there the mandatory reporting rules apply as far as abuse and neglect, and also we'll go over like ethical standards for educators. But DAPA licensed, that's Tiana's territory. That gets more complicated, but school psychologists, school counselors, those who are not DAPA licensed, basically bottom line, follow the Utah educator standards, and we will cover that. So if a student comes out to you, do you have a policy? Do you have a policy in your district? I can tell you now there's no policy in the state. There's no policy at the federal level. So does your district have one? Or your school, if you're a charter school, do you have one? Because that's where you need to start. And hopefully you've got some guidelines there. And if you don't, it's good to have a conversation about that with your administrator, so that is something that can become more clear, because that puts you in a really compromising position. But in an office where it's just you and a student, it might look a little bit different than in the classroom. So it is 203, 53-9-203, and that's the one that Tiana covered as far as the things that cannot be covered. But this is where I think the confusion comes in, where we're talking about that one free session is because when a student spontaneously expresses, hey, Ms. Bell, I'm gay, that's a spontaneous expression. That's not something I need to do anything with. I don't have to call home. I don't need parent consent to continue to talk to that child. A spontaneous expression or disclosure is not something that falls under an activity that needs parent permission. It's when you just, from that point forward, depending on the nature of the type of support that the student is trying to receive, then you're going to have to make that determination. But you also need to be aware that this fourth bullet is also in statute that school personnel may, so that's not a shall is a have to. They may provide information observations to a parent about the student, including the observations and concerns about progress, health and wellness, social interactions, and behavior. So sexual orientation and gender identity could easily fall under one of those. And it says a school personnel may provide, but we not provide information to parents, but we need to be thinking about our intention behind that. We need to be thinking about what the student is telling us as far as if there's anything that needs to be reported, as you know, if there's a serious threat that to the child, and that's what DCFS is for. If they're afraid of abuse and things like that, because sometimes they do. There's a high proportion of, especially of the LGBTQIA student population that are homeless in Utah in 2019, out of like 2,000 homeless youth that had been homeless over the past year, that 40% identified as LGBTQIA plus. And so that's concerning that they are at risk sometimes, and we need to make sure that they are safe. And so if they express some concern, that you follow the mandatory reporting laws. I don't know. I like to spell out acronyms. I always assume everyone knows what LGBTQIA means, but I should not make those assumptions. So quick overview: lesbian, L, lesbian, female identifying, attracted to female identifying, G, gay, often associated with male identifying, attraction to another male, and then also female to female. And then bisexual is attraction to one or more other gender identities. And when you see my wheels turning, I actually just told you sex rather than gender, but we're not going to get into that complicated level of detail. So then we've got, what do I got? The LGB, the T, transgender, that is not identifying as a gender that aligns with your sex assigned at birth. Q is queer, which kind of is an umbrella term for all sexual and gender diversity. I is intersex. That's when you have a combination of sex characteristics. And then A is asexual or agender, so no association with a sexual identity or gender. It's okay. That's the quick and dirty. There's a dictionary if you really want to get into more detail. I'm going to stop and ask if there are any questions, because I'm going to go over educator standards. We have any? Okay. So when we talked about the ethical code of educators in rule, so these are your R277. This is what the Utah State Board of Education has spelled out to us. These are, when we get our license, we have agreed that this is the code we're going to stand by. So these are the may nots: shall not participate in sexual, physical, or emotional harassment towards a colleague or a public school age student. We can't expose them to material that we know would have been appropriate given the age maturity of students. We cannot interfere or discourage the student or colleagues' legitimate exercise of constitutional, legal, or civil rights. We can't exclude them from participating in any program, or deny or grant any benefit to a student, or encourage a student to develop a prejudice on the basis of sex, political or religious belief, physical or mental condition, family or social, cultural background, sexual orientation, and gender identification. So this is what you may not do. Now, what shall you do? You should treat every student with dignity and respect by promoting the health, safety, and well-being of students. Take prompt and appropriate action to prevent harassment or discriminatory conduct toward a student or school employee that the educator knew or should have known may result in a hostile, intimidating, abusive, offensive, or oppressive environment. Take prompt and appropriate action to protect a student from any known condition detrimental to the student's physical health, mental health, and safety or learning. So this is our mindset. This is how we make decisions, especially if there's an absence of policy of what we can and cannot do when a student comes out to us. These are the terms that we have agreed to as educators when we make our decisions. So, and I always say in this conversation, we need to be asking ourselves, when we're looking at civil rights, it's about equalizing treatment. It's not treating one identity over another. And that comes up in also Utah rule and law and code. And so what would we do in the instance, like I gave the example of, hey, Ms. Bell, I'm straight. So what would you do in that instance? And so kind of asking ourselves, okay, this has come up with this student who identifies as gendered or sexual diverse, student. And so what would I do for a student who was not? And how would I handle that? And so that can help us when we're making decisions to kind of reverse the role and see how would we respond in that circumstance, taking into account all of the things that are listed here as far as promoting health, well-being, preventing harassment, and taking appropriate action, like making our decisions based on this framework in front of you. But please don't call home if they just tell you. That's something that comes up all the time. And it starts getting complicated when they ask to use different pronoun or name. And typically for the classroom, that can look a little bit different. When it's in your office, it's not as big of a deal because it's not, that's something you can keep confidential within the office if that's, going to provide a safe or more comfortable environment for the student. If they're referring to them by a certain pronoun, it's not something widely publicized, but then it can get tricky when it gets into the classroom, it gets outside of your office, because we want to make sure we're involving parents when it's appropriate for the child, but because they are the primary caregiver, they have primary responsibility, and we can't villainize them and think that they're all, they're not in support of their child. It's just such a tough balance. So what if they ask you to use a pronoun or name that's different than the one in the student information system? Is there a policy? I am not aware of a single district that has a policy about this, as far as very clear, succinct, this is what you should do, unless the parent is supportive. If the parent is supportive of the child and the parent approaches the district or the school, that's different. I have seen that. But if the parent is not supportive, I have not seen anything definitive. If you have one, please raise your hand. If someone has told you, here is what you do in all circumstances when this is our policy, when a student wants to use this pronoun or name and the parent is not supportive, this is black and white answer. Anyone have that out there in your school? Yeah, no, yeah, I'm not aware of anywhere. And so these are tricky questions. And so if there's not a policy, again, we follow our educator standards, what's going to be best for this child because of the parent role, and that they are the primary authority. And you want to work with them. You want to invite them in and have them involved with their child. But are they always supportive? No, because it's hard. It's, you know, they have expectations for their child based on their own personal experiences and beliefs and hopes and dreams for their child. And it looks different than they expected. And they're having to deal with that. And it's difficult. It's difficult for a family to move through these kinds of adjustments and changes and often challenges for them. And we're in a secondary role that we're just trying to be supportive, and we want to make sure that the child is thriving and feels included and feels respected and is not being harassed. And that's where our role comes in. And we've got our own belief systems that we're bringing in to the environment. And so we're walking this little tightrope. But we need to make sure that we have a fair process, and that we have these, you all are really good at conversations. So having conversations with a student to help them walk through and critically think about how them moving through the world really looks in reality. So if they ask you to use a different pronoun or name, how does that look in reality in everyday life? How's that going to play out? Especially if they don't want their parents to know. Parents always find out. And especially if kids are calling them a different name or pronoun than that's on the school record, they find out. And so what are we going to do? How are we going to support this child and their family? So there is a new law that just was passed, Senate Bill 100, the school gender identity policies, that does say explicitly that schools have access, or parents should have access to the educational record of the child. So anything that is in the system, the parent is required by law to have access to. And your own personal notes and things like that, that's not part of the education record. The education record is what is in the system. So they can't change, a student can't just come in and say, I want to change my name on the system. I want to, you know, this is my chosen name. These are my chosen pronouns. They can't do that unilaterally. They have to have a parent do that for them. So now that you all know in absolute certainty what to do when a student asks you to use a different name and pronoun than on record, do you have any questions? I'm glad I could clear that up for you. Did you get questions on this today, Sammy? Did they look at you like you're the enemy after you had to give them that answer?
There were a lot of questions and we were like short on time. So it was kind of like all of my answers were talk to admin if you have questions, because that's a little bit above my pay grade. I mean, obviously I can give support and advice and everything, but as for the policy and following those things, it was mostly like, go ahead and ask admin and see what they think and what they say. So
I would add a layer to that and look at the policy yourself. You're all intelligent, smart human beings. I would not depend on my admin to interpret the policy and make a decision on that. Personally, I would read it myself. If there's no clear thing, I would read it myself. So pull it up. Pull up your district's policy.
I love that. I should have told them that this morning.
Look it up.
Well, it's true. And this is why we're here going through all of this jargony, boring language, because if you don't know it, you can't make informed decisions. You have no way to protect yourself. If you do know it, if you study it, you think about it, then when someone questions your motives or your actions, you can say, this is what I'm basing my actions off of. I have been told not to harass, to establish an environment of harassment for this child and for all of the kids in our school. And so this is what I'm basing. And, I don't know what all of your administration is, your administrators come in all different shapes and sizes and beliefs and opinions and practices. So, but they are kind of the bottom, they're the heat is on them as far as when it all comes down, that the administrator has to answer to all of it. And so really establishing clear communication with your administrator can be protective for you. But like I said, not all administrators are made alike. So I have no idea that you might disagree with what I just said. So yes, know your laws. My slides used to look so different, not that I was out there trying to, indoctrinate anybody as far as how to support LGBTQIA kids. It just looked different. Everyone wanted to kind of talk about best practices and things like that. And now in the climate we're in, they just want to know what they legally can and cannot do, which, is so clear. Are we allowed to say gay? So that's, and then, along with that, are we allowed to say trans? What can we talk about? This is the question again. What can I talk about as far as students who are heterosexual or who are cisgender? So their gender identity aligns with the sex that they were assigned at birth. What can I say? What can I do? It's the same. And it looks a little bit different in health class when we're talking about the no promo homo law. This was a health education law that was that had some amendments based on a lawsuit, and because it had contained the term or the phrase that you couldn't advocate for advocacy of homosexuality in the health education curriculum, and that was rescinded. That was stricken in 2017, which, so essentially we're not going into the intricacies of sexual behavior in any of our classes. Health education, like sex education, is pretty clear as far as what you can and cannot teach. I'm not going to go through what that definition is, but acknowledging that there's differences in attraction is actually in the health standards, acknowledging like an individual's various identities. Like I said, we were very multifaceted, faceted, complicated beings. Acknowledging that students have parents that are the same sex, that students, acknowledging that fact is not against the law. In fact, one could say that to absolutely, dismiss a student who has two moms because you don't, you can talk about the student who has a mom and a dad, but you can't talk about the family of the student who has two moms, that's discriminatory. So we're asking ourselves, well, how do I acknowledge all students according to who they are? But I'm not getting into the details about how they have sex, hopefully, or their romantic attraction, because we're not trying to get our students to have sex at that young age. I don't want my kids having babies while they're in high school. So I'm not going to, sex education has their own thing, but we're not getting into the details anywhere else. And that's the thing, is everyone focuses, when we're talking about sexual and gender diversity, they focus on the sex part. It's really about romantic attraction and attachments that we have that are very normal, social, desirable functions of humanness that help us be healthy individuals. And so just thinking about things more around romantic attraction is where I kind of try to get people to think about this a little bit more. But they always kind of we always sort of try to veer over here in the sex world, and as educators, like, I don't know, health teachers, you can deal with that. I don't, counselors, I'm like, no, I don't want to talk about that. So questions about, can we say gay or trans, or allowing you to be the person you want to be and try to figure it out?
So real quick, there weren't any questions in the chat, but there have been some good comments. And I'll just say at this point, if anyone did want to share a comment, or Delia, I don't know if you feel comfortable kind of sharing what you shared in the chat. I think that would be valuable now, but you certainly don't have to.
Sorry, am I still muted?
No, you're good. We can hear you.
Oh, okay. Yeah, I was just a little confused on, I guess I don't know my district's policy, and I should probably read up on that, but I have a transgender son and a bisexual daughter, so I'm just kind of figuring out how to navigate this. Like, as a parent, I think it's tricky because we have to be sensitive to that. A lot of these kids don't have family acceptance or support, so we have to be careful about what we I don't know, be careful about the confidentiality, I guess. And because I've had my son kind of outed by teachers, where the teacher will refer to him as his dead name, or just kind of, or just announce that he's transgender, which he's doesn't necessarily want to share because he's passing as a male. And it's just been really tricky. And as far as professionally, I think the big thing is if I feel like I need to involve a parent, I just kind of think, would I be involving the parent if this student was straight? Or it is, because sometimes I think it's all this there, it's very confusing, all the different types of identity and the gender stuff and the romance stuff, and it's a lot. So I think I have to ask myself, would I be treating them, would I need to involve the parent if a student that was straight, or a situation with that? So that's all, I think. Thank you.
I really appreciate you sharing your personal insight based on personal experience. And that is complicated. I'm sure you could tell us a lot of stories about what this journey has been like for you as a parent.
Yeah, it's been I think the biggest support I've gotten is just like through like an online kind of group of different different moms that are navigating this. But it's hard because I can see like both sides, like as a educator and as a parent. But I think the bottom line is that a lot of these kids or individuals feel like their safety and their rights are being taken away and threatened, and outing someone isn't just, gonna make their day harder or be a kind of a bummer. It can be a safety issue.
Mm-hmm. Yeah, and when we think about equal treatment, that is something that we do have to ask ourselves is, okay, so if I were to disclose to a parent of a child who is straight, what might the outcome of that be? As opposed to like, because maybe if I equally applied that, where it's not a big deal if I did that, but if a student who is romantically attracted to another, student of the same gender, if I were to report that, how's that going to go? What's the outcome going to be of that? So thinking ahead about that might look at the outcome might look differently, even if we are applying things the same. But that's always a great launching point to ask yourself, what would I be doing if this student were not sexually or gender diverse? I see there's another comment here from Julia. Provo District. Yeah, the Provo District policy is not extremely clear. Probably the most straightforward is straightforward is Salt Lake City School District. Let's see, it does not define what it. Yes, they do have a policy, a very clear policy, and it's about and so age appropriateness and this making decisions based on age is definitely something I've seen in all the policies. They treat it a little bit differently if the student, for Salt Lake District, the cutoff is, I think, 5th grade. And then they have different procedures from after 5th grade. And then Provo is age 18, which I think that, you know, at age 18, that's kind of just, they have different rights as an adult. So definitely they have to be informed with official changes. They can't make official changes without the parent involvement. And that's in all cases throughout the state now, especially since Senate Bill 100 was passed. And, you know, with the hearings with that Senate bill, there were a lot of, there was actually a school psychologist I heard at the hearing, because the first initial drafts of the bill were not clear on this confidentiality piece for school mental health providers. And there was a lot of concern expressed that if you were required to out a child to the parents, that could be harmful in some cases. And so in the end, when the final bill was enrolled, it did not contain language that was explicit, that was saying that you have to out a child in all circumstances. Any other comments or questions on that? Okay, some of you might have safe zone stickers, flags in your office or outside your office, or other stickers. So the question is, can I have that flag up? What can I have up on my walls? Again, as all of them, what's your policy? Do you have a district policy? Do you have a school policy? There are several cases that have been interpreted. So looking at case law, that a local education agency, so that's a district or a charter school, they can enact a policy controlling what symbols and signs are allowed in the school environment. And so you will see that there are policies out there as far as flags are concerned, whether it's the American flag is required in statute, but any other flag that's really not spelled out anywhere. We have to look at the different laws and rules that are in place with what can be in the classroom environment, but they can make a policy. So is there a policy in your district? Anyone have, because I know some of the districts that have one. Any of you have one that you want to share? Can you have a rainbow flag up? Okay. Some can, some cannot. So student rights are a little bit different. Because when a educator walks in the building, their free speech rights are different. They're more limited as far as what your role is as an educator and how free speech works. It's limited. Student rights are different. They have more free expression, as long as it's not materially and substantially interfering with the requirement of appropriate discipline in the operation of the school and without colliding with the rights of others. And again, they can enact policy about that. This statute right here, this is from 2023. This is an amendment to the Constitutional Freedoms in Schools statute that already existed. This was Representative Jimenez passed this bill. It's educational and constitutional freedom. And so I highlighted the word display because of the first place in law that display is actually included in regards to kind of the educational equity space. Again, it's not explicit as far as what display means, what cannot be allowed, but there are certain rules that have to be followed with just not promoting or endorsing that one identity is superior or inferior to another, and making sure that what's reflected in the school environment does not communicate that either. So what that would look like as far as symbols goes, that it would be equal treatment to have, if you had a rainbow flag up, then you also had a straight flag up. There are straight flags, by the way. They do exist. So to be equal, and I know the intent is not to have, with rainbow flags, I know the intent is, in most cases, is not to make a political statement. The intention with a rainbow flag is to show inclusion. And some are interpreting it as a political statement and an elevation of that sexual orientation, gender identity over another. And so to allow one flag is, in order to be fair, you have to allow others. And I don't think that includes flags that explicitly are promoting hatred, but flags that are that are reflecting an identity. If you're not going to be discriminatory, you have to allow both. But so I always have people ask the question to themselves, what is my intention in having that, having these symbols in my school? And is that the only way to basically display these safety signals for students to understand that they are included? So does that mean if your district allows you to hang a rainbow flag in your classroom or office, you must hang a straight flag? Like I said, there are no strict rules about what flags. There's nothing that says what flags. There's just this overlying sentiment that you can't be promoting one over the other, that you can't be setting up an educational environment that is communicating that one is superior to the other. So there is nothing really clear as far as what kinds of flags we're talking about. It's just what they represent. We can't be like distinguishing, like if one group of students that is part of the straight club wants to hang their flag, we can't say, no, we're only allowing the GSA to hang a rainbow flag. That is just deduction based on the laws that are there, not like you have to do one thing or the other. But just reflect on what your intentions are and how you go about doing that without creating I'm just saying that, well, the LGBTQI community does not have like they don't own the rainbow. Rainbows, I think, are okay. You know, the arch thing, that unicorns and leprechauns and those, they don't own the rainbow. So to have rainbows and to have kids like draw rainbows and display them on the board with the rest of the artwork of their friends, I can't see justification in taking that down. So yeah, like Tiana said, it's most likely they'll just say you can't have any flags, and that's kind of what's happening. But if your intention is to promote safety, have symbols that kids can see that, hey, I feel included. And it really, like, I was in a Lyft ride on my way back from New Orleans, and our Lyft driver, my Lyft driver had a Star of David on his, a BYU student had a Star of David on his keychain. So he's both Jewish and a member of Church of Jesus Christ of Latter-day Saints. And I saw it, and my partner is Jewish, and I was like, look, he's got a Star of David. And it just automatically gave a feeling of, oh, that's so cool. Like, there's not very many Jewish people in Utah. And that's cool. It was like conversation starters so that they could connect and be like, oh, what synagogue do you go to? And stuff. Like, it really does make a difference when people, if they are kind of a minority population, to see that there's these symbols around, that can be a connection for them. And so to see a rainbow kind of makes them feel safe. That was a really fun conversation, actually. Yeah. But so with symbols, some districts are saying, like, in your personal space, as far as your lanyards, you know what you're wearing, like the personal effects on your desk and things like that. If they're making more policies around that's not controlled, whereas what you put on the wall is. But when it starts getting a little wild, as far as, okay, that student drew a rainbow, you can't put that up on the wall, but all the other kids who drew, I don't know, cars and teddy bears can, like, that's discriminatory. That's, you know, especially if stuff like that starts to happen, where it's like same gender parents can't have their family photo on the desk, but other, you know, the traditional, like, heterosexual family, that's then we're getting into really discriminatory territory. That stuff that is in the classroom environment, they can make policies. And this is where we get into kind of the considerations on what can be promoted and or what shall not be promoted or endorsed. So that's that these identities are superior or inferior to another. That identity determines the content of their character, values, morals, ethics. That an individual is inherently racist, sexist, or oppressive. This is language from the statute that I was talking about. Whether consciously or unconsciously, solely because of their race, sex, or sexual orientation, or that meritocracy or character traits, including hard work, ethic, are racist or associated with or inconsistent with any racial or ethnic group. That's getting into a different conversation. But this is the language that you need to be aware of. In your instructional materials, in your in your professional learning, in your displays, that they're not communicating these ideals. And they shall not promote one ideology over another. regarding a topic, or attempt to persuade a student or instructional or administrative personnel, which is defined in the law, but basically, to say it short, it's everyone. Instructional or administrative personnel is like everybody, and that includes you. So not attempting to persuade them to a point of view that's inconsistent with the guiding principles for education, educational equity and individual freedom, including that all individuals are equal before the law and have unalienable rights. And the intention of these laws, as stated in this one, and then the Educational Equity in Schools Board rule, which was passed in 2021. They're not intended to prohibit or ban discussions regarding these identities, or certain events or attitudes or beliefs or concepts from the general sharing and participation in the marketplace of ideas, fostering a learning environment. The intent is that educators go into these conversations in a neutral way, in an unbiased way, that they're more of a facilitator than inserting their own ideas to instill into the minds of the youth in their care. So that is the intent of these guardrails that they've put into place, not to silence, but to try to encourage a more facilitation and neutral facilitation, acknowledging that everyone has bias. Questions about symbols? I don't see anything in the chat. I was able to pull it up. Okay. You probably have bookshelves in your office and libraries and have wondered, what books can I have that have content or characters that are sexually or gender diverse? So last legislative session, the sensitive instructional materials statute was passed that put, these are pretty clear actually. Now, the way they're being applied might not be as consistent as far as what's being challenged. Different people might have different ideas of what is age appropriate, because that's what a large part of the conversation is what is age appropriate. But they're pretty explicit about what pornography is, and pornography is not allowed. And there's some really clear definitions of what pornography are. And I'm not going to read them to you because they're kind of pornographic. You'll learn new vocabulary, maybe, that certainly. So you cannot adopt, use, distribute, or provide student access to or maintain in the school setting sensitive materials, or permit a speaker or presenter in the school setting to display or distribute sensitive materials. So when we're talking about school materials, instructional materials, we're talking about videos, books, websites, like any sort of medium that you would use to instruct children, cannot be pornographic. Now, I already kind of told you this. So there are books like, it's tricky when you talk about books for in this particular area, but this is a good place where you could think to yourself, are we, if I were to replace a character in this story with someone who is not sexually diverse or gender diverse, if I were to replace this character with a straight or cisgender character, would I be able to have it on the shelf? And so I have children's books. I have a real passion for children's books, and I did several book lists last year, one a month, on different communities. So I did one for families in October of last year, and it has a variety of family representation. So there are single families, grandparents, same sex, same gender parents, traditional heterosexual families. Like it's all about families, and the books have that. And in my mind, when I go through and I look at these books, I think to myself, if I were to have another character, could I place any other character in this story and have it be appropriate for school? If the answer is yes, then to me, that is, like, I didn't get to pronounce, is it Delia? I don't know if I'm pronouncing that right. That's answering that question of like,
Yeah, you're right.
So am I making a decision? Like if I decide I'm too afraid to put Sparkle Boy on the bookshelf, am I making that decision because this child's gender expression isn't what we traditionally think of for a boy? And if that's your answer, then you might need to question yourself, like, well, why is that the gender expression that a boy has to have? Sparkle Boy doesn't have anything to do with his gender identity or sexual orientation. He's an elementary school child who thinks that what his sister gets to wear is pretty cool and wants to wear it too. And that's gender expression. So it's on the list, in the summer list. It wasn't a fan. Not everyone was a fan. But I love Sparkle Boy because I have people call me and say, I have this little boy whose mom puts him in a dress at school and he's getting made fun of. And I say, all right, well, maybe that's a good learning experience for the kids in the classroom to understand that it's not okay to harass kids based on what they wear. And so if that child is coming to school in a dress, the child needs to be able to learn, and they can't do that if they're being harassed. So we have Sparkle Boys in our school. We also have girls that wear pants. I don't know if you noticed. In fact, I have a book about a girl who wears pants. The first girl who started to wear pants. When's Women's History Month? March? February? Yeah, no. February's Black History Month. Anyway, check them out. I love those books. We're going to bring it in and then I'm going to give it to Ashley. So, well, you'll probably take a little break. I just want to bring us back to our main focus and the message from the Board of Education. They stated that we call on Utah schools and on ourselves and on people everywhere to abandon attitudes of prejudice against any group, to take action to create and maintain an environment of dignity and respect for all, and to strive for understanding. We commit to learn from the past, but we'll focus on our efforts to building a bright and equitable future. As long as we're making our decisions with that in mind, we need to follow policies. We need to adhere to them, but we can't forget that the children that we're serving and their families are at the center of our work, and making sure that if that's our focus, then and we make our decisions based in that mindset, we'll do what's best for kids and keep them safe and able to learn and be successful. That's all I have for you.
Awesome. Thank you so much, Holly and Tiana. Does anyone have any questions that they want to ask real quick? And I'll give you a second to let that sink in. If not, we'll probably go ahead, let's go ahead and take our 10-minute break right now, and we'll come back at 3:30 and have Ashley take it away. Does that sound good? Some thumbs up? Okay, all right, so 3:30, we will pick it back up right on time. Okay, this is your 1 minute notice. We'll be coming back together in 1 minute at 3:30. All right, it is 3:30, so let's go ahead and pull everyone back together. Thank you again for being here and participating. I should have said this at the beginning of the training. I forgot to. Having presented occasionally on these Zoom or virtual opportunities, I will say as a presenter, it is nice to see as many faces as possible just to get a little bit of interaction that way. So if you do feel comfortable having your video on, I suspect our presenter would appreciate that, unless maybe Ashley feels differently. I don't know, but I just encourage you, if you feel comfortable, go ahead and turn on your webcam so we can see some faces and have some connection. Thanks. All right, Ashley, go ahead and take it away.
Okay, thank you. I am hoping my dog will behave for you guys. I apologize if not. He tends to be a little bit of a barker. So, okay, let me see if I remember. I'm going to share my screen here. Okay. So my name is Ashley Biehl. I am an assistant attorney general, but the Utah State Board of Education is my only client. So I am housed at the State Board of Ed, and I only deal with K through 12 education, so not higher ed. And because I'm a lawyer, I have to put the obligatory lawyer disclaimer that my presentation does not constitute legal advice and does not create an attorney-client relationship. So just the boilerplate from me on that. So today my presentation is going to be focused on DCFS and school interactions. We've been getting a lot of feedback that that's become an increasing trend. There's a lot of questions about what that interaction looks like. So I'm going to be addressing that. And this kind of goes into my background. I spent a couple years representing youth in care. So kind of collides my two worlds together a little bit. So some background information. The Utah Juvenile Code is in Title 80, Chapter 2 of state law. And the legislative purpose of that is to protect the best interests of children, offer protective services to prevent harm, stabilize the home environment, preserve family, etc. So a little bit of the background of kind of how these cases happen, because I think a lot of people don't understand. This is something I've had a lot of questions about, just the basic mechanics of a child welfare case. So typically a report goes into DCFS or law enforcement, and the first step is what they call a pre-custody interview. So that's the very first step, is their investigation into the report. And oftentimes that is when DCFS employees will be coming out to schools to interview children at school, because sometimes it can be done without a parent present. And I'll get into that more. But if allegations are made against a parent or parent's spouse, then those can be done without the parent present. And so that's why the school is oftentimes considered a neutral place for those to occur. And so the question often arises that I get is, do all these kids that are interviewed, are they removed from the home? The answer is no. A lot of cases, DCFS either close out with no findings, or they open in-home safety plans. So I think the statistics are that less than 40% of cases result in removals. And then at the time that a child is removed from their home, they go through an adjudication process with the court, and the courts have to make a finding, like a criminal trial, that the child was in need of protective custody, and then they become a ward of the state. And that's where they're often placed in foster care or with a family placement. And at that point, the school, usually the admin, is notified of the change of guardian, which will affect records mostly, because parents often, even through a DCFS case, do retain educational decision-making rights. So very often parents are still, like with IEPs, parents are still allowed to be involved through a DCFS case. Okay, so reporting. So Utah law is a mandatory reporting state. You must report if you know that a child has been abused or neglected. And I'll get into those definitions a little bit more. Either to DCFS or to law enforcement agency, and then they have obligations to notify the other. Reports are strictly confidential, so your name will not be given to the parents or the student. Individuals making reports in good faith are immune from liability. So if you make a report and what you're saying turns out to be false, the parents can't sue over that, as long as it's made in good faith. And persons failing to make a report are subject to criminal penalty. So again, it is mandatory. Utah law requires it, and you can be held to criminal liability if you're not reporting abuse or neglect that you know is happening. Okay, so that duty goes even a little bit farther, I would say, with mental health professionals, where the normal standard, if you look back, for just any citizen of the state is reason to believe a child has been abused, and here it's so the same, reason to believe, or observed circumstances, conditions or circumstances that would reasonably result in abuse or neglect. So abuse is more typically what you think of in these cases. You're typically thinking of your physical abuse, your sexual abuse, human trafficking, non-accidental harm, things like that. Neglect is often a little bit harder to spot. So it can be abandonment of a child, leaving them alone for extended periods of time. I've seen cases of 13-year-olds being left to watch their 1-year-old sibling for a week at a time. That's considered neglect. Failure or refusal of a parent or guardian to provide proper or necessary subsistence, medical care, or other necessary care for the child's health, safety, morals, or well-being. So we'll get into that question a little bit more of, what if a parent is just refusing to engage, refusing to act, or step in to meet a child's medical needs. And then educational neglect, which I will say, very rarely a case comes in just for educational neglect, and that would often be attendance issues. So kids not being brought to school, kids, essentially not showing up repeatedly, habitual truancy. But those typically come in with other pieces to them. I'm going to pause real quick because I saw there were a couple of comments. I didn't see if they were questions, so let me glance at those real quick. Okay, so great question from Bethany. If a student's foster parents and birth parents are actively involved with the case and working towards reunification, who has educational rights in that case, and who is allowed to or should sign the IEP? So the short answer is that in most cases, the parents retain educational decision-making rights throughout the case if they're working towards reunification. So typically the parents retain those rights and they should be at the IEP meeting. Now, it's usually up to the discretion of the parents, the school, and the biological parents as well, if the foster parents are involved, which very often they will be, because at that time, they're the ones with the kid in their home. They're the ones who are assisting with the homework. They know what's going on. So I've seen cases where both parents and foster parents attend, but parents most frequently retain educational decision-making rights. If they don't, that is typically a separate court order that is done. And it's usually in cases where reunification is kind of off the table. The parents have up and left, they're not engaging in their case plan, they're not active and present. But if the parents are showing up, they're present, they're able to serve, the courts typically leave them as the educational decision makers. Sorry, I'm just scrolling through these here. Yeah, so when in doubt, so legally, the state is the custodian when a child is in foster care. So the first contact you want to be talking to is their social worker, because the state has legal custody of them. So the foster parents don't have custody. They are just given, kind of physical custody, but the state has legal custody of them. So talk to the social worker first and foremost. And they should know whether the parents still have educational decision-making rights. Secondary contact that would be really great is the guardian ad litem. So the children's attorney will probably have a lot of insight into that as well. And yes, the caseworker should be aware of the status of who has the educational decision-making rights. So definitely check with them. Okay. Would a child who has been removed from the home and placed in protective custody have McKinney-Vento-like protection to be able to attend the same school, or would they just be considered child who has moved and have to apply for a special permit or something if they want to keep attending the same school? It is in the law that children have the right to remain in their school of origin. So that should be the standards. Kids should always be staying in the school. It is a legal obligation that the division has to provide transport, even if the child is from Provo and they are placed in a foster family in Bountiful. The division has the obligation to provide that transportation. So yes, and there are cases where, the children don't want to sit on the bus for an hour, or they don't want to be transported an hour across town, or they're staying with an aunt and they want to go to school with their cousins. And that's fine if that is what the child wants. They get a lot of say in that. But yes, the standard is DCFS has to be providing that transport for them to stay in their school of origin. These are great questions. I really appreciate them coming in. Okay. So suicidal ideation and bullying. So the first step in Utah law is to report to parents first. So in Utah law 53E 9-203, if a school employee or agent believes a situation exists which presents a serious threat to the well-being of a student, that employee or agent shall notify the parent without delay. So as a shall, it's a must. In 53G 9604, notify a parent, a school shall notify a parent if the student threatens to commit suicide, or notify the parents of each student's involvement in an incident of bullying, cyberbullying, hazing, abusive conduct, or retaliation. So those are both shalls, they're not may. Have to report those things to parents first. That is the first step. So the question comes up, what can I do if I report to a parent that a student has expressed suicidal ideation and the parent does nothing, the parent ignores it? So the broad rule is that if a parent refuses to take recommended steps of action for intervention, a school psychologist can contact DCFS. It's permissive, you can, to make a report of neglect if there's a serious imminent risk to the child's safety or safety of others. So there's a specific provision in 53G 9-203 that says generally mental health professionals cannot make a report to DCFS just because a parent refuses to consent to a psychiatric, psychological, or behavioral treatment, or psychiatric or behavioral health evaluation. So typically, if they just say, no, I'm not willing to do the evaluation, then that's not reason enough alone to contact DCFS. However, if that is coupled with there being a serious imminent risk to the child's safety, then at that point, it is allowed that you can contact DCFS as neglect. And that goes back, if we go back to that definition of neglect here, to subsection 3, failure by the parent, to provide proper medical care or other necessary care for the child's health and safety. So it's kind of a thin line there. It can't just be because of them not being willing to do an evaluation or seek treatment, but if it's coupled with that imminent risk to self, then it can be a report. Okay, how does DCFS respond if a school reports that a parent refuses to have their child evaluated for a mental health related crisis, e.g. active suicidal ideation, after it has been determined via suicide risk assessment that the student is in a state of immediate risk of suicide? Yes, so that is the exact right situation to contact DCFS if there's an active imminent risk to the child's safety and the parents are refusing to have an evaluation or seek treatment. Then that is the time that you can notify DCFS, and then they will go through their investigative process to see if in their minds it raises to the level of constituting neglect. And then, like I said, they have kind of their different pathways of they can open an in-home safety plan. So where DCFS is involved, but the child stays in the home, and they can just say, hey, we're going to work with you and provide supports, and we're going to provide family counseling, and we're going to take these steps, but the child is safe to stay in the home. Or if it's really bad, or they find underlying abuse that's causing the suicidal ideation, whatever it may be, that the child is unsafe in the home, then at that point, they would petition to the court to remove the child from the home. Okay. So school cooperation with DCFS investigations. So once a report has been filed and there's reasonable cause for DCFS to do their pre-removal investigation, they have the rights. They can do that in a lot of different places. Schools are specifically included on the list that they can come to do that pre-removal investigation. So as a part of that process, they have to use an interdisciplinary approach in handling that investigation. And they're supposed to convene a child protection team to assist in the protective diagnostic, assessment, treatment, and coordination services. So the team is chaired by a DCFS representative, but includes, when possible, health, mental health, education, and law enforcement agencies. So DCFS might ask a school counselor or a teacher or an administrator to get involved at that time. And I'm going to go over next kind of what the do's and don'ts are of serving in that role. But I would go back to Holly's advice on this and say, check with your district's policy on what their policy might be on your participation in that team. Your district might have some specific guidance on who you have to notify, whether you have to have permission, things like that. So State Board of Ed, like Holly was saying, we have rules. So rule R277401-3 requires local education agencies. So that's either your charter board or your school district, so like Salt Lake County School District, to develop and adopt a child abuse and neglect policy, which shall include at a minimum the following provisions. So each district has to have a policy that contains provisions on these topics. That includes allowing access to students. So that should be what their policy is on DCFS's access to students at school. Allowing authorized agencies to interview the children consistent with law enforcement and their protocols, DCFS protocols. This is an important one, making no contact with the parents or legal guardians of the children being questioned by DCFS or law enforcement authorities. So that obligation lies solely with DCFS, and I'll get into a little bit more what their obligations are, but that is not the school or administrator or counselor's obligation. And the policies have to have information on maintaining appropriate confidentiality as well. So absolutely not the administrator, counselor, teacher's job to contact parents if a child is being interviewed. Also, a school district has to maintain anonymity of those reporting. And again, that's also in state statute that DCFS also has to retain that anonymity. That is a struggle word for me. Okay, so DCFS interviews in school. So they they can be on school campuses. It's actually under federal law. So like Holly was talking about, that very top level federal law, that school campuses are allowed to be included. So if you are asked to join in this interdisciplinary team or serve as a students can have a support person in a school in an interview. So the first thing that's DCFS's obligation is they have to assess if the child is comfortable with the interview and the interviewer and the conditions, things like that. If the child is not comfortable being alone in the interview, they are allowed to have a support person that they choose. So it could be a parent, it could be a religious leader, it could be a teacher or a counselor. The only requirements are that person must be over 18 and reasonably available. So that could be any of you. So some of the do's and don'ts of serving as a support person is that you must refrain from contacting the parents. Like I said, can't contact them. And then also, unless you're told to by DCFS, again, that obligation is legally theirs, they own it. And then if you are asked to be present at the interview, you must not influence the child through any statements or reactions. So you're there to be a support and an encouragement, but you can't influence the statements that they give in any way. So parental notification, again, just goes back, DCFS. It is their obligation. School person should not do it. The question arises, what if a parent calls while this child is in an interview? What do I tell them? Staff members should not confirm or deny that an interview has taken place. Just refer them to DCFS and law enforcement for any questions that they might have. So just can't confirm or deny. It's the basic dealing with like reporters kind of standard. So their process, so what DCFS's notification requirements are, just so you kind of have an understanding. You don't need to know this in your head, but they are required to notify parents in advance unless of that initial interview, unless the child's parent or step parent or parent's boyfriend or girlfriend is identified as the alleged perpetrator, or if the alleged perpetrator is unknown and the perpetrator's relationship to the family is unknown. Those are the only two circumstances in which they shouldn't be notifying parents first, which, to be honest, most of the cases that are being reported are being reported on parents, or against parents, I should say. And then in either of those two situations, DCFS has to notify within 24 hours of the interview occurring. So again, nothing that you guys have to do, but just so you know, those are their requirements of what they have to notify. Okay, so school records and FERPA. So the basic rule is that FERPA, which is the Federal Family Education Rights and Privacy Act, prohibits the disclosure of student records without prior written consent of the child's parent or the child if they are 18. Schools and school districts should have policies providing that all the requirements of FERPA are satisfied and appropriate individuals receive appropriate information. So one kind of exception here is that FERPA allows for the release of student information without parental consent to appropriate officials in cases of health and safety emergencies. So DCFS investigation could rise to that level or could not. And which student information is given also varies. DCFS might need to know if the report is for educational neglect. Their attendance records are obviously going to be very pertinent, but maybe their grades are not. So the one kind of across the board rule of what schools can provide to DCFS upfront is what they call directory information. And directory information is defined as information contained in an educational record of a student that would not generally be considered harmful or an invasion of privacy if disclosed. So basically, it's the child's name, the fact that they attend there. So if DCFS calls and says, hey, we have a report, does this child attend this school? The school has to provide that information up front. But as far as specifics into what other records have to be provided, like mental health records have specific protections and confidentiality, right? So that your district should individually have a policy that defines what level of notes and records should be given. So like I said, it's going to be on a case-by-case basis with that. I wish there was a brighter line there. There's not. It's just what's appropriate in the cases of health and safety emergencies. So some of that might depend on the urgency of the situation, what's causing the case to come in. And again, your schools should have policy on that. So when in doubt, talk to the district or pull their policy and see what the policy is on it. Utah has a couple of specific provisions. So when reports of neglect are based on or include allegations of educational neglect, Utah law specifically requires DCFS to consult with school authorities to verify the child's status in accordance with 53G 6201 through 53G 6206. So that goes back to the school can't deny or, refuse to provide if the child attends there. They have to verify the status in school. And DCFS cannot close investigations on the ground that they are unable to locate the child until all reasonable efforts have been made to locate the child, including contacting of schools. So that goes back to same thing. That information just has to be provided under Utah law if a child attends that school or not. So that is kind of the end of what I had. I am happy to take if there are other questions, things that arise from that, please let me know.
Thank you very much, Ashley. I've got one question that I'll just put out there. In working with one of my schools, it's a Title I school, and there have been a number of times this year and in previous years where they've needed to make a DCFS referral, and they've gotten to the point, and I'm a kind of in more of a consultant or collaborative role, so I'm not this is not my first person knowledge, but what they've told me is that as they make these reports to DCFS, very often they seem to be told or communicated the message that that DCFS will only investigate, and again, I don't know what language they've used, but what they call closable cases. That very often they're told, yeah, that's not really something, it's like, yeah, thanks for calling us, but no, that's not really something that would be closable. Does that, I don't know, do you have any comment on that? Or, and again, this is what they've told me, so I don't know exactly what language has been used, but they're at the point where they feel like there's kind of not a point in even calling DCFS, and I'm continuing to encourage them. We are mandated reporters, so report it, right? Keep going through the process, but yeah, that's a frustration that they've expressed.
Yeah, absolutely. And I've heard that frustration from the field as well. And they have a tough job, they get a lot of reports, like it's certainly not easy. And to me, I think in hearing that, like, what is the difference in closable, right? I mean, there's, like I said, there's a different standard of opening a case where the child's on in-home safety services and opening or having a case that if you're removing a child from the home, those parents have rights, like, you don't have to prove it to the same level as a criminal trial, right? It's not beyond a reasonable doubt. It's a preponderance of the evidence standard, but a prosecutor has to be able to prove those allegations by a preponderance of the evidence. So more likely than not that they're true. And they're your trials. And so it's definitely a different standard with that. But in my opinion, that should never be a factor in whether an investigation even occurs in the first place. And yeah, like you said, I mean, everyone in Utah is a mandated reporter as far as, you know, if we suspect there is likely that it meets that level of abuse or neglect. But especially with, you know, teachers and psychologists being kind of that front line. And with Utah having that criminal provision that if you knew something and didn't report it, they could sue you or, you know, take you to court. I would say when in doubt, absolutely make the report. I know it's frustrating if you're being told, you know, they can't do anything, but just, I mean, from the old, you know, CYA background, like absolutely better to report and at least have that on the record that you did report.
Megan, thanks for raising your hand. Did you have a question or comment? If you do, you are still muted.
Maybe we can have Megan put your question in the chat box because it appears we're having trouble with the audio.
While Megan's typing that up, thank you, Ashley, for presenting. This was super awesome and super helpful. I was curious about you said like the transportation, right? They have to provide transportation to that kid's homeschool. Do they like I have a family in my school right now who like they live in Bountiful and we're down in Riverton. So is it the foster family's responsibility or is it DCFS's responsibility to transport them?
Great question. It is DCFS's responsibility. So it is not the foster family's responsibility. Oftentimes DCFS will kind of pass the buck and say, hey, are you able to do this? Will you do this? And I think foster parents are generally good people who want to be helpful. And so they sometimes end up doing it. But at the end of the day, yeah, it's the district, the DCFS's obligation to pay for that transport. So I've seen it when I was working Las Vegas where DCFS was paying for kids to take Ubers to school every day. Yeah.
Ashley, it looks like Megan's comment is in the question or in the chat.
Yes. So Megan said, I think you might be talking about substantiated versus unsubstantiated cases. And even if they are not opened up, these cases for information are still logged and can come in handy later. That is very true and a very good point. Goes back to the question of, you know, should I keep reporting if I'm being told, you know, no. So those unsubstantiated cases are documented when they when they're called in, they are documented, and that can be considered in future cases, you know, like, hey, we've had 6 reports, they've all been unsubstantiated, which just means we don't have enough evidence to open them. It doesn't mean that something didn't happen. It just means that we don't have enough evidence to open it. But, you know, now that we have six reports, this is looking like a pattern. It's a little more concerning. Maybe we should take a look. So that goes back to definitely when in doubt, make the report.
I have a question. We had this come up in one of our schools where a student had suicidal ideation, but was afraid when she got home, if the school called her home, that she would be beaten. That had happened in the past. So the school made the decision, or the school psychologist made the decision went to the administrator. The administrator said, no, you need to call home. The school psychologist made the decision to call the police and DCFS instead, and then got in trouble by her administrator for not following their advice. What would you suggest in that situation?
That's a really tough one. It's one where I struggle personally a lot with some of the things that Holly was talking about, with things that ultimately are outing students, or things like this where you know that telling a parent is potentially going to result in harm. And to me, with this background, I think about those things a lot. I think about, if we are telling this parent something that they don't want to hear, am I putting this child in harm's way? It's really scary, but Utah law says that we have to. And so I was just going to go back and look briefly at those statutes that I posted that were on the suicidal ideation and reporting, and see if there was a timeline, because one thing I was going to say is I think that there is the potential to call DCFS, make that report, and then notify the parents 48 hours later and give that kind of system time to kick in as maybe a preventative step. But I don't want to give that advice or, say that before I look at those statutes and see if there is a mandatory timeline on when that reporting has to be done. So
I think the wording is without delay.
okay. Yes, it is. You are right. Without delay. So,
But isn't that, Ashley, isn't that if there's a severe threat to the child, they have to report to the parents without delay?
yes, the language is.
Otherwise, there isn't anything except a may report certain things to a parent. But the only time they have to report to a parent is if there's a severe threat.
Yeah, let me do this. This is the specific language right here. So, serious threat to the well-being of the student is report without delay, and then shall notify a parent if the student threatens to commit suicide.
Yeah, so it's
Can
only
I-
those two conditions.
Can I ask for clarification when we say threatens to commit suicide? I mean, students saying like I'm suicidal versus a student saying I have a plan and I'm going to go home now and enact that plan. So could you do that 48 hours in that case and give DCFS a chance, in the case that Kirsten brought up, giving DCFS a chance to go and do their thing if it's not a like imminent threat to that student, right? Maybe they're just thinking about it, but they're not actively suicidal. We're not worried about immediate harm. So is that a case where we could give 48 hours versus, there's a gun in the student's backpack type of level of risk?
I'm going to say, Holly or Tiana, do you have any thoughts on that?
I would imagine that type of lower risk would not be picked up by DCFS to begin with. Potentially, and maybe Ashley.
Well, I mean, in response of like, if you call my parents and tell them I'm even thinking about suicide, they're going to beat me. That's the kind of situation I'm talking about.
It's tough because it comes down to that parsing of language, right? That lawyers love to do, but it's that parsing of the phrase threatens to commit suicide, and how, you have to report if they threaten to commit suicide. So, is saying, hey, I've been thinking about it. Is that a threat to commit suicide versus I actively have a plan. I have something that I'm going to do. I'm going to do this tonight. Like that obviously would meet that standard.
This may also be more clearly defined in your LEA's policy as well. Some might say in their policies, you have to notify a parent within 48 hours or 24 hours or something. So I would check your policy, your local policy as well, just to cover your butt. But I was always told in my district, you call no matter the risk immediately.
Oh no, we definitely do. I just,
Yeah.
I know the situation Kirsten's talking about on a
I was
very
also
personal
gonna add-
level, so I was wanting to know.
I was also going to add earlier that there may not be an obligation, depending on what your policy is, but an obligation to notify. I think the scenario was something about they got in trouble with the administrator for calling DCFS. You may want to look into your school's policy too about what is your obligation to tell your administrator or staff these cases with your administrator. There are some policies I've seen where you have to report any DCFS reports to your administrator. But that puts you in a tough situation when your administrator doesn't have the same level of understanding as you do related to mental health concerns. And I would always staff it with another mental health professional as well. And so you're not just staffing with a principal, you're staffing with somebody else that gets it a little bit more. And then you've got kind of two perspectives against the one.
I have a question for all three presenters, but I don't want to share it if there's any questions that are specific still for Ashley. Okay, well, I'll go ahead with my question for all three. I just have to say thank you again for coming. I feel like we've had these great presentations this year, and last year we had many of you for our very small on-site presentation that touched on some of these topics, but I don't know if everybody else feels the same way I do. I feel like this is a conversation that could happen every month because things change or new things come up. If each of you could maybe speak to suggestions or resources of ways we can continue this conversation or continue resource sites to, because I mean, honestly, I'd love to have this be like an annual thing we do, but is there a way that the three of you feel all of us as practitioners can stay abreast of updates with any kind of policy change, obviously following like UEA and all of those components, but I sometimes that is so technicalities that it's like I need a little more guidance. So if any of you could have ideas and could speak to that, I really appreciate it.
Well, I don't know if you all are aware. I'm going to put a link in the chat for the resources for LGBTQI plus students from the Office for Civil Rights. So Title IX regulations have flip-flopped back and forth, and regulations that come out of the Office for Civil Rights are controlled from the federal statute, but there is no federal statute that is very explicit. So the Office for Civil Rights has made their interpretations of what exists. And so, like I had mentioned, and all you can find all of this information from the link that I put in the chat. The Biden administration, based on the Bostock decision, is for adult discrimination of transgender. The Supreme Court made the decision that you could not fire a person from your business if they were transgender. So based on that decision, then the Biden administration said, okay, well, we're going to apply that, or the court said we're going to apply that to Title IX. And so there's been proposed revisions to Title IX that would include more protections for students based on gender, sexual orientation, gender identity, and those are supposed to drop next month. So if they are on time, but I would presume that would be next month or a couple of months after that. So once that happens, you need to know what Title IX specifically protects. And you can actually, I think the link of the proposed, amendments to Title IX are linked on this page if you wanted to look and see what the proposed amendments are. So those could go into effect in May, or well, I would have to look and see when they say that you have to adhere to them, but that is going to change the landscape of how we are legally required to address students who are sexually and gender diverse in our schools. So that's something you're going to want to stay on top of. And for now, they released a fact sheet called it's called Confronting Anti-LGBTQ plus Harassment in Schools, and I'll just put the chat directly. And what this does, because even though the Title IX regulations have not officially changed, the Office for Civil Rights investigates discrimination allegations. And actually, court cases back years and years and years have, the preponderance of them have, or the majority of them, I've got that preponderance of evidence now in my head because they use that for Title IX. So the majority of those cases on sex stereotyping were, especially when it comes to bullying for students, how we were talking about gender expression. So sex stereotyping and presumptions of sexual orientation or gender identity, the courts have resolved cases for the person or the child that's sexually diverse. So even with this lack of clarity in court cases going back years and years, if there's this sex stereotyping coming into play, then they're supporting the child. So so this right here, OCR, if someone makes a claim of discrimination, OCR has given some explicit examples of what they would be inclined to investigate. And so even if it's not the force of law per se, they do have the ability to give corrective action. I don't know if you're familiar with Davis School District and everything that's taken place with the Department of Justice and everything. So they can take corrective action if based on their investigative findings. They can reduce funding, they can, they have to, they can make them do trainings and hire staff. And so even if, that it's not going to court, that's the authority that the Office for Civil Rights has. So you can look at that fact sheet and say, and kind of make your determinations as far as what types of things, even without the regulations having been changed, are they going to investigate if they're reported? That's what comes to mind right now. Now I'm going to have to keep my wheels turning. And if you have questions about anything specific.
I would say as far as school mental health, there's not a lot changing fast. I would say any like general broad school mental health things, it's a very slow process of changing things. So I wouldn't expect any like big things happening like in between legislative sessions probably. But I always love doing like case scenarios. So if your association wanted to host other trainings related to this, or even like small group, like bring your scenarios. How would you apply the law? How would you apply the board rule? How would you apply your policies in your districts to these scenarios? And just do a lot of case consultation and scenarios and pretend play about how we would handle situations. I think that's always helpful to kind of pre-game, like game plan what you would do if a situation came up. Any opportunities for those I think are super beneficial.
And I would just say, so like the USBE every year after the legislative session creates a document that's like the legislative kind of guidebook of all the bills that were passed relating to education. I'll link that for this year. So I would say at the end of a legislative session, if you wait a couple weeks, you can always go back and look at that, and you can kind of, Control F to search for like any trigger words that you might be looking for, specifically changes related to like mental health or psychology or, LGBTQ, whatever you are looking for specifically within that document, and just kind of search. And that comes out every year after the legislative session. So that's a good place to kind of track state law updates.
And another thing I would suggest is that if you are sitting there wishing that you had a policy in place for certain things, you can advocate for that. You can advocate to your administrator for a policy in the school. You can advocate to the district, to the state for a policy that provides clarity if you think that there's a need. Because if you don't communicate it, and if you have a teachers union, that's something as well that they can advocate for other policies and things. So if you want to see change, then you have to advocate for it.
And I would say advocate even for changing existing policies if you think that they're unethical or going against your professional values.
One question, I've heard some administrators out there that seem to have a view that if we don't put anything in local policy, then we can't get in trouble for doing something wrong. From a policy perspective, do any of you have any comments on that, or things that we could use to advocate for, like, it's a good idea to have a local policy, assuming that the policy is decent, but.
Well, that's what I was saying earlier is, I think a lot of the attitudes around LGBTQIA+ students is that it's so individualized. And sometimes if we get broad sweeping policies, it doesn't allow you in the individual attention to the specific needs of the student. And so the flexibilities, aren't there if they're very rigid. Oh, the book list took you to OCR. Sorry, squirrel. So make sure that's right. So that's the thing, like you said, you need to make sure that you're thinking about the whole picture. That's why, I also the Section 504 specialist for the state, and 504 tends to be quite broad. And it's very, very much, and even special education, very much that you need to focus on the individual needs of the child. So sometimes you don't want to have policies that are so strict that it doesn't allow you to meet the individual needs of the child. So just think through, adults that we actually have that ability. When adolescents haven't quite got that yet. Think ahead.
And I'll just say, I think, state statute and board rule both dictate oftentimes where LEAs have to have policies. And so if they don't, never hurts to point out, hey, we noticed, this USBE rule says that we're supposed to have a policy here and we don't. I took the liberty of drafting up a policy I think would be really great here. Here's a couple of other teachers who were in on this and provided feedback. And just kind of being proactive about, staying on top of where policies need to be and just always advocating for positions and for your students that, for policies that are going to be good policies. Because I think oftentimes, sometimes loud minorities overtake majority viewpoints, especially, just in this world. And so just having kind of a collective group of people who can have expertise on the policies that you guys are drafting and saying, look, we group together this group of teachers who all thinks this is good policy, always going to help a lot.
An example of that is in that state law that talks about needing prior written consent for if you're going to be soliciting information about mental or psychological problems or sexual orientation topics. That law actually is telling LEAs they have to have a policy on that. And most LEAs are copying that and saying, this is our policy, but not providing any other guidance or clarification about what those terms mean. The biggest one that comes up the most frequently for me is, what does it mean to solicit information about mental or psychological problems? Does that mean asking a kid how they're doing on a survey when they come see you in their office? Or does that mean doing a full psych eval? And there's not a lot of clarity around what that term means. So that is a potential area where maybe it's more helpful to have it be broad so that you can kind of have some flexibility in working with kids. Or you're finding, actually, we need more clarity here. We need to know what this means so that we are carefully making decisions about when we interact with kids without parental consent.
Well, and I want to add on top of that and then get to know Naomi. That's something that's come up, that particular law has come up with, because something that has been a practice in schools is to survey kids at the beginning of the year about, their interests, their, getting to know you kind of thing. And educators have asked if they have a different name they prefer to be called by, or what pronoun that they like to use. And so a couple of years ago, the superintendent, along with not Ashley, but our other AAG, sent out an email to all the superintendents that said, this type of surveying is not allowed based on that particular statute. And so, but it's not explicit in the statute. And if they don't have a policy about that, then that's another question left up in the air. Naomi?
That kind of relates to my question, because I remember when all of that was happening and a lot of our students, I'm in an elementary primarily, and even 5th, 6th grade, 4th graders started going up to their teachers without being surveyed and saying, hey, I want to be called like they, them, or he, him, or a different name not related to their birth name or a nickname in any way. And they were really conflicted. And even my administrator was like, we're not quite sure how to handle it. There was some draft guidance that came out, but nothing really solid to help them feel comfortable and say how to respond to the kids. So I was just curious y'all's thoughts on it.
Well, you didn't ask, so there goes that surveying part. So you didn't violate that part. And yeah, the guidance didn't go out. And that's one of those circumstances where you have to go back to, well, okay, there's two parts to this. So I'm thinking, we have a lot of kids who their name on their record isn't what they're called at home. My parents, it may say Will Smith on the school information system, and at home they call me Billy. Do I call that child Billy? That's not what it says on the roll. And so it happens, especially in elementary schools. Well, I mean, every year at the beginning of the year, you're kind of like, okay, I've got this list, and you're calling it all out, and they're like, I don't want to be called that. And it's not even having anything to do with their gender identity. So that's one of the questions is, if we're looking at non-discrimination, how are we going to apply this question to all the students in our room who may not want to be called the name that's on the list? And so that's a question to ask your administrator. If they don't have a clear picture about it, just say, well, but they're not the only ones. My gender diverse students are not the only ones asking. I've got other kids that are saying that they want to be called something different than William. So what am I supposed to do? And that's never been a question that people have been asking in the past. They've only been asking that when students started asking more and more about different pronouns and chosen names. And I mean, my pronouns that I use are she, they, because I'm a cisgender woman, and they is a gender neutral pronoun. So I use that like regardless. If I don't know someone's gender identity, I don't want to make assumptions based on their gender expression. So I just use it until I know for sure and someone self-discloses that. And it's hard to learn that. It's hard to do that because I'm, socially for the last 50 years, I've been I've been, genderizing everyone. But that's just something across the board I could do with my classroom students and feel comfortable because that, Webster Dictionary says it. So does Shakespeare. So those are the kinds of things that maybe if your principal is confused, ask them, well, we can't be discriminatory. So how are we going to handle this for all of the students? I said I had two parts. Did I cover both the parts?
I think the first was the parent consent one. And the second was
And you
how to
can ask the parents, you can ask the parents, you just can't flat out ask the children apparently.
Yeah, and I think the concern with asking the parents is that teachers unintentionally outing the student if they're coming
Right.
up asking about a different pronoun and things like that. So that's come up a lot, just even the past 3 years with my teachers, and they're just so anxious of doing something to hurt a kid or making a parent mad that's on the front of their mind.
Well, and if you are a trusting adult, these children, and if they will know, they can tell, and they will probably self-disclose, and then you can, then you're going to have to figure that out. Oh, based on the educator standards. So will your response align with what you have committed to? You have personally, not your administrator, you personally that got that license, you applied for it, you paid for it, you got that license, you agreed to those. And so you are the one that has to, when it comes down to it, you have to say, I made this decision based on what I committed to as an educator. And you have to determine that. It's your own ethical code, but based on, you know, your license. So that's really the bottom line, but yeah, no, and then my train of thought just left the station. Choo choo, just pulled. If anyone wants to get me back on some kind of track, go for it.
I think that's a good point, Holly. When things are gray, go back to what standards exist and then make an ethical decision when there's gray area. And like, do you feel like what exists in the standards you are complying with? And can you back that up if there were ever to be somebody questioning your choice based on what exists in the law and the standards?
And I think what I was thinking of is I was just thinking of those students that are looking for someone to connect with. And they will connect with you if they know you're trustworthy. You don't really have to go and survey the school for all the queer kids.
Yeah, what we have more now is just they're very, and it's great for them. It's not even just a trusted adult, it's announcing it into the front of the entire class in school, and it's part of their identity. And again, I love it for them. And then the teachers are like, I want to support them. I want them to feel safe and respect them and all the things. I'm like, well, then you do what you have to do that, but make sure that we're just following the law with that and protecting their rights as well. So it's, yeah.
I think sometimes people feel afraid because they don't know what the laws are and they
Yeah.
don't know where to find them or how to interpret them or how to like, so any chance you can get it when teachers come to you, point them back to it, say, here, this is where I know this law exists, or I went to this training and there was some gray area and it's not as clear in this area. So helping them feel more confident and knowing where the laws exist, where the hard lines are, and maybe where the more gray area is might help the teachers feel a little bit more confident. They don't have to depend on someone else telling them. They can find that out for themselves.
And really don't assume parents are adversaries. Just try not to make that assumption. I don't know if there's any Sex and the City fans. But the new version, if you are into it, you got to see Charlotte and her child and the journey they go through, because Charlotte's a supportive parent and Charlotte's child is just doing their own thing, and they find out that they're I think non-binary, and they were in the dark, and they're in this position where they're like, I totally would be supportive, but my child didn't include me, and now everyone else knows. And so it really, I didn't know that I'd learned such life lessons from Sex and the City, but it just was one of those moments that I was all, yeah, that would be hard as a parent. There are a lot of things my kids did not tell me until after the fact, and I was all, what? I am like the most open parent in the world, and you didn't tell me? You know, I'm not an adversary. They're trying to support, but their kids are being kids, and just, but sometimes they have a really legitimate reason to be afraid. So it's hard to know, but just don't make assumptions that the parents are out there like, brr. Bethany, you're a fan. Yeah. People always tell me I look like, what's her name? Carrie, Carrie, is that?
Carrie Bradshaw.
Yeah. I want all of her clothes.
I would like her shoes. Yes.
Tiana? No, you didn't like her style?
I didn't watch that show.
Oh. All right, I can tell it's not quite your generation.
I did watch the new one that came out with the young Carrie Bradshaw, the cute one where she's young, and as I watched that one, but not it was like on I don't even know what channel it was, but it was
Sarah
cute.
Jessica Parker. Yeah. She's my doppelganger. Look at this nose. I mean, I totally own it.
Can I get back to what we were talking about with advocacy?
The topic at
Okay.
hand, yes, please.
Not Sex and the City. So we have a very active legislative committee that does a lot of work every year on the Hill. And there's a ton of things, obviously, that we can advocate for in our profession. But do you have any certain areas that you see are big gaping holes in, say, state legislation around certain issues that we could help advocate for in our profession, as we do this all the time anyway?
Are you all school psychologists?
I believe at least 90% of us are on this.
So one of the things, and Tiana and I have talked about this after this last session, is and Tiana, I think you got it on your slides, the law that talks about who are mental health professionals. And it says psychologists or school mental health professionals. Like, school psychologist is not on that list. And it complicates things to not have them on that list. And so maybe you can talk more about that.
So there's, I would say, discrepancies where certain professions are listed in certain laws. For a long time, the only professionals in schools that were like called out in laws were school counselors. That's slowly changing, I think, to include school psychologists and school social workers, or encompassing them all as school-based mental health professionals. So that could be an area, is to go through and see where the discrepancies exist and make sure all of them are listed, or there's no or maybe better defining in the law what they are and what they can do might be an area. But yeah, I would say different pieces of law call out different things, call out different professionals, and it's not necessarily inclusive of everybody that's doing that job or playing that role where in real practice, I think.
I think that's a great point. And I think one of our wins this year was being added to the Grow Your Own bill that we were excluded from. And
Exactly.
So, yeah.
That was a big thing I was advocating for when I first came on, was, hang on a minute. We do this work too.
Was it school nurses too that were part of that, but then not school psychologists? Anyway.
So school nurses weren't considered in the Grow Your Own one, but forever, I don't think, but definitely the school counselors and school psychs being added to the Grow Your Own.
Yeah. What else came up?
Another big thing that I think was part of the I just lost the word, the one Elison put out with like the thing that Holly said doesn't actually mean anything. It's not
Resolution.
Yeah, the resolution.
Yeah.
Those can lead to laws.
Yeah.
I have seen that happen.
I would say that would be,
yes. To the
I would say
concurrent
that would be an
resolution.
area to focus, is what's in the resolution and how can you move that work forward. A big thing in the resolution was related to ratios and how do we get more mental health professionals in schools, get more funding around these professions, because that's what it's boiling down to right now. From what I can tell, is people want more of us in schools, but there's not enough funding. Yeah, so that might be an area of focus, as well as increasing the mental health supports through funding.
There was something I thought of earlier that's not pertaining to legislation, but that's pertaining to requirements in schools that people don't know about. Do you all, as school psychologists, do suicide prevention training? Is that part of your responsibilities? Bethany's kind of. I'm just wondering how aware all of you are of the requirements in suicide prevention and bullying, cyberbullying, hazing, abusive conduct, training rules and reporting, because without there being any sort of a accountability component to the training requirements, I just kind of wonder if they're happening.
Like a standard.
Because the suicide prevention for secondary grades, there was an amendment in, oh gosh, it's been like 4 years, that you have to, part of your suicide prevention needs to cover family rejection in any circumstance, but it specifically talks about lesbian, gay, bisexual, transgender, and I think they include the Q, that it explicitly states that you have to include that in your suicide prevention about family rejection, because family acceptance is such a buffer for students' mental health who are sexually and gender diverse. So that is in there. I don't know if it's happening. Bully prevention is the same, where you have to include bullying based on all the civil rights laws, and student characteristics such as sexual orientation and gender identity, disability, religion. It calls them all out in the bully prevention training, and that needs to happen. There's even a explicitly outlined that it has to happen for all school employees, students. So are they giving training on civil rights, like bullying prevention of these specific student groups that are in that bullying rule? I don't know. If you're not seeing that happening, and if you're part of that training, then someone's got to call it out. It's a law.
I'm just trying to find a link to the board rule that defines the training to link it for you guys.
For the suicide prevention, or for
This one's the bullying.
Okay. And then the suicide prevention, bully prevention is for all. And it's very explicit about like how often as well. It's like within the first year, and then every, that you're employed in every 3 years. And the educational equity in schools board rule is required for all educators. And that pertains to those guardrails that I was talking about, but it's about educational equity, and that's a whole other board rule. So the bullying is for all grades, all coaches, volunteers, educators, teachers, everyone has to have this bully prevention training.
Can I ask a clarifying question? Are we talking about training the staff, training the educators, or are we talking about giving a training to the students?
Everyone is supposed to get that training.
Oh, okay. We've had like suicide prevention training for our students, but
oh, you're talking about suicide prevention? That's for students. And I think perhaps there's a parent component to it, but for suicide prevention, so not bullying, not suicide prevention, that is for secondary students.
Okay.
And then and you might want to invite Kathy Davis to come and talk to y'all about suicide prevention. But there is also a teacher or a parent component to suicide prevention training.
The last link I just put in was the state law about suicide prevention training. And it outlines for elementary grades and secondary grades what needs to be included in there. And that also includes training related to preventing bullying and cyberbullying. And there are funds available to support those training efforts as well. The parent one that I know of requires districts to provide parent education on a variety of topics, and they can choose. So one of them is related to bullying, one is suicide prevention, one is mental health topics, so that the LEA can choose which of those topics they want to educate their parents on. It's not all inclusive that they have to do all of them.
My guess is that some districts cover that training in their SEL curriculum in terms of bullying and suicide prevention and things like that.
Potentially. I'm wondering if it's getting to the levels of the disaggregated groups, that the levels that are in the board rule.
I wonder that too.
I mean, because that would mean that they would need to cover sexual harassment. Because Title IX gets into sexual harassment, and that would be, not to mention the health education, which at the elementary school level, anyway. There are a lot of training requirements that I really wonder if they're happening.
Not seeing any other questions in the chat at current time.
All right, is there anyone else that has any questions? And again, we want to thank our presenters for coming, and I know Holly said that she might need to step out a little early, so if there are no other questions, then we will go ahead and again, thank everyone for participating. Thank you for your great questions and the interaction. I love that we've been able to ask these questions and get some good comments and feedback. As a reminder, anyone that has participated and that's been logged in will get an email with the professional development certification and certificate and information on how to get that on Midas as well. So thanks again, everyone, for participating, and I hope you all have a great weekend.
Thanks. Take care.
Okay, see ya.
I was just throwing in the chat. I want to catch you before you go. I have a listserv for school psychologists.
Yes.
Where I send some information about upcoming PDs and USBE updates. So if you're not on that and you want to be, I try to do it once a month. It's definitely not as much information as you probably get from UASP, but if you're interested in being added to that, just email me. I'll put my email in the chat.
Okay,
Tiana,
thank
I
you.
have to say thank you for doing that, because we oftentimes will re-spotlight some of those trainings in our monthly newsletter. So thank you again to everyone.